Mr. Levey, I'll start you off with the next question. At issue here is the constitutionality of a local public school board regulation mandating, as part of its K through 6 curriculum, attendance by students at a course on gay marriage, which the particular state recognizes, to promote tolerance and understanding of children who have two moms or two dads. Parents who object to the subject matter on religious grounds have sued the school district to enjoin mandatory attendance of their children in the course.
Well, as a general matter, I think that the state has broad powers to determine what is the proper education for children. Again, as a matter of policy, I may not agree with that, but I don't see much of a constitutional basis for disagreeing. Certainly there is a line of Supreme Court cases which talk about parental rights, but frankly I think that's fairly activist. I don't really think there is a strong constitutional basis for there being a competing parental right there. If you're talking about a religious right, that's different. There clearly is a basis in the First Amendment, but again, the courts have found, and I think rightfully so, that schools get a lot of deference here. I'm not sure exactly where I would draw the line. I mean, given that gay rights is not directly related to religion, it's not like they're forcing you to take a course saying there is no God. I think my ideal justice probably would side with the school board here.
Professor Roosevelt, how about your ideal justice?
Well, once again, I believe we find ourselves in agreement. I agree as a general matter, certainly, that school authorities have broad discretion in choosing a curriculum. I think we have to recognize that public schools are designed in part to inculcate values, and the state gets to choose those values. Now, perhaps that sounds like it's bad policy. Perhaps it sounds like it's going to standardize children and run roughshod over parents' religious beliefs. But the remedy to that is not to send your children to public schools. I think it simply would not be workable if we allowed parents who disagreed with various elements of a school curriculum on ideological grounds to exempt their students from that. With religion, I might at some point draw the line. I expect I would draw the line in a different place than my colleague here. But given that public schools, generally speaking, are not, for First Amendment reasons, in the business of taking positions on religious issues, and given that I certainly don't see a course on gay marriage as an attempt to make children endorse a particular religious belief or participate in some kind of religious exercise, my ideal justice would say liberty of conscience is respected by giving parents the opportunity, and in fact the constitutionally protected right, not to send their children to public schools. If they send their children to public schools, they have to, for the most part, take the bitter with the sweet. This is not an example of something from which they could get an exemption.
So your ideal justice would feel that there is no right by parents to send their children to public schools?
My ideal justice would feel that there is a right to send children to public schools, but not to determine the content of what is taught there. There's a right to send children to public schools if you wish. There's a right not to send your child to public school. There's a right to have your child educated in the manner that you choose if you do not send that child to a public school. But you cannot combine the rights, as it were. You cannot say my child will go to public school, but while there will learn only what I approve of.
Thank you.